Good morning, everyone. Thank you all for being here. I wanted to briefly start by introducing myself. My name is Perzanowski. I teach intellectual property law at Case Western Reserve University School of Law, and I'm really excited this morning to get a chance to talk to you about a project that I've been spending a lot of time on over the last several years. It's currently taking the form of a book that I'm about halfway through writing that, if all goes according to plan, will be published next year by MIT Press. So it's been on my mind, and I'm always eager to share these ideas with other people and kind of get your thoughts and feedback. So I actually want to start with a couple of questions. Just by a show of hands, how many of you in the last couple of months have bought a book? And by book, I mean like a physical object, bound pages, put together, right? So most of us, right? What about ebooks? How many people have bought an ebook in the past 2 or 3 months? Fewer, right? And that's a fair reflection of the way the book market looks right now. Physical sales are still, if you combine paperback and hardcover, are still doing better than ebooks, but ebooks are growing really quickly. So most of us think about this choice as really just a matter of sort of personal preference. Do we like the smell of ink on paper? Do you like the feel of a book in your hand? Or do you like walking around with 1,000 books in a device that can fit in your back pocket? But there's actually something really much more fundamental at stake when we make that choice between those two formats. There's this really kind of a growing rift between the rights of people who buy tangible products like books or records or DVDs and people who buy digital products, right? Ebooks, MP3 albums, digital movies, that sort of thing. And this sort of gulf separating the rights of these two groups of consumers is a result of a bunch of recent both legal and technological and marketplace changes. You combine expansive, low-cost cloud storage with ubiquitous high-speed internet connections. One of the things that does is it takes these objects that we sort of surround ourselves with or have historically surrounded ourselves with out of our hands and out of our homes and puts them in the control of other third parties. We see more aggressive intellectual property law combined with restrictive contractual provisions, technological locks that sort of limit what you can do with the things that you buy. Collectively, those have kind of weakened consumer control over the intangible digital goods that they acquire. So these shifts are kind of undermining and at the same time redefining our conception of ownership. And pretty profoundly, I would say, shifting the way our assumptions about personal property seem to work. So what do I mean by that? If you buy a print book, it becomes your property. It's like your car or your toothbrush or like your favorite pair of shoes. You own it. You can do lots of things with that personal property. You can keep it as long as you want. You can use it as many times as you want. You can give it away. You can lend it to a friend. You can resell it. You can put it in your will, right? Your library at home on your bookshelves. Eventually, right? This isn't going to happen soon for any of us, but eventually we're all going to die, and something's going to happen with those books, and you get to decide what happens with them. None of that is true right now for your electronic books. Most of us have probably never even sort of stopped to think about this question. Do you own your ebooks? You might think you do. You click the same Buy Now button on Amazon.com that you click to buy any other product. We will come back to that point in a few minutes. You paid the money that they asked. But according to Amazon, you don't own those purchases, right? That transaction is not governed by the traditional rules of personal property law. It is governed by the terms of a 8,000-word end-user license agreement that no one has read. including the Chief Justice of the Supreme Court, who has publicly said, I don't read those things. You'd be crazy to read those things, right? That might be a sign of some sort of dysfunction in this market, right? So, there's this massive collection of legalese that every sane, rational consumer clicks I agree without reading. If you sift through those thousands of words, there's one very clear, consistent message, which is you do not own the thing that you just bought, right? You licensed it. What does that mean? Well, I think what Amazon means by that is you get to use the thing that you paid for under whatever conditions they deem appropriate today, right? And maybe those terms can change over time. So let me give you just one example of what that lack of ownership looks like in this context, right? Most of us probably read George Orwell's 1984 at some point, right? Maybe we read it in high school. If you don't remember the sort of dystopian classic, the Ministry of Truth, kind of at the behest of Big Brother, would destroy documents that became sort of inconvenient for one political reason or another. They would cast them down the memory hole. The memory hole was this sort of collection of tubes that led to a massive incinerator, right? So when information became inconvenient, it got destroyed. If Amazon customers who bought 1984 had a chance to read it, they would have found it ironic that one day they woke up after Amazon got in a dispute with the publisher of the book. Not only did Amazon pull the book from its Kindle store, it remotely deleted the book from thousands of customers who bought it, right? They went to bed owning the book. They woke up the next morning and the book is just gone. No one can do that with your physical books, right? Your favorite bookstore, your least favorite bookstore, the public library, no one gets to come into your house and take your stuff without notice, or even with notice for that matter, right? So that's a bizarre world to live in some ways, and one that I think is very inconsistent with what consumers would expect. So mostly this morning I want to tell you the story of kind of how we got to this place. And to do that, we've got to understand a little bit about the basics of copyright law. I'm sure some of you already understand this, but let me take a couple minutes just to lay out some fundamentals here. So copyright holders, right, the authors of books, the people who make music and movies and software and video games, and typically their labels and publishers and studios get certain exclusive rights, right? Things that they're allowed to do with a copyrighted work that no one else is allowed to do. Those include reproduction, making copies, distribution, the selling, the lending, the transfer of copies of the work, publicly displaying and performing the work, making derivative works based on the original. Our primary focus here is the distribution right. So the distribution right allows copyright holders to control the sale of copies, the lending of copies, the rental of copies, any kind of transfer of ownership. But there's a really big, important limitation on that exclusive right. In copyright law, we typically refer to it as the first sale doctrine. More generally, it's referred to as intellectual property exhaustion. It's the idea that once you sell a particular copy to someone, the copyright holder doesn't have control over that copy anymore. They still have control over the intangible work, but they don't control the copy that they sold to you. That's why we have used bookstores. It's why we have used record stores. It's why we have public libraries. It's why we had Netflix when Netflix was in the business of actually mailing people DVDs. It's the reason you can lend a novel to a friend without asking the copyright holder for permission, right? And I think this is a really good reminder that, we typically think about copyright law as regulating intangibles, as regulating sort of these abstract mental creations. And that's true for creators. For consumers, copyright law is about telling you what you can and can't do with your stuff. Can you hang that painting up in a public place? I don't know. Go ask copyright law. How many people can you invite into your house to watch the Super Bowl? I don't know. Go ask copyright law. Bizarrely, how big can the television be on which those people watch that program? I swear copyright law cares about how large your television is under some circumstances, right? So it's a pretty direct way of regulating how consumers use the things that they own. So there's this tension here between the intangible rights of copyright holders and the very sort of personal property-like interests of consumers. And we've mostly mediated that tension for about 130 years now, going back to a case involving Mark Twain's attempts to control the distribution of Huckleberry Finn. About 130 years, we've had a pretty clear set of rules in place to figure out this sort of question. You know, and it's a system that has worked reasonably well. And one of the reasons it's worked well is because this exhaustion idea is really crucial to a functioning copyright system. It's not just good for consumers, it's actually good for the copyright system as a whole. Why? One thing that exhaustion does that I think is incredibly important is it provides incentives for consumers to participate in copyright marketplaces, lawful, licensed copyright marketplaces. And this is more true today than it ever was. Every copyrighted work that you can imagine is available for free on the internet somewhere, right? Usually not lawfully, but it's there. So copyright law is asking something sort of remarkable of consumers. It's saying, hey, that thing that you want that's free, why don't you pay us for it? Why would you do that? Why would you make that decision as a consumer, especially as a 20-year-old consumer, right? Well, one reason is you're worried about legal liability. Right? The point of copyright law is to sort of increase the costs of infringing behavior, right? We create copyright infringement liability. We impose remarkably high statutory damages in copyright law, up to $150,000 per work infringed. That's a pretty strong and meaningful stick. But the likelihood of being caught, the likelihood of being sued is pretty low. Is there some sort of carrot that copyright law offers consumers as an enticement to actually go out and buy stuff? I think one carrot, one really important one, is that you get something valuable in exchange for your money. You get personal property rights. You get rights that are stable and predictable and can't be taken away. Your books don't disappear in the middle of the night if you pay for them. You can give them away, you can lend them, right? They come with all of these valuable rights that otherwise are not available. So exhaustion, I think, is hugely important in that respect. The bigger thing that exhaustion does, the more sort of fundamental thing that it does, is increases the efficiency of the marketplace. So exhaustion manages information costs. So there are all sorts of transaction costs when you engage in any kind of exchange. One of those costs, at least in the copyright context that's really important, is gathering information about the product that you want. In a world where rights are determined by 10,000-word end-user license agreements that differ from one another depending on what vendor you're shopping with. Are you buying from Apple or Amazon or someone else? Depending on the terms that are imposed by the particular publisher of that work. There's a lot of research that consumers have to do if they actually want to know what they're getting themselves into. So those information costs are potentially incredibly high. And they're incredibly high in the context of a transaction that is of relatively low value to the consumer. You're spending, $15, $12 on an ebook, $10 on an MP3 record, 99 cents on a song. How much time and effort are you willing to invest in that transaction to figure out exactly what bundle of rights you're getting? If we have clear exhaustion rules that follow the basic premise of personal property law, We don't have information costs in that sense. We already know what we get, right? Have you ever bought a book at a bookstore and wondered, what am I allowed to do with this book? What are the rights that come with it? Can someone take it away? Am I allowed to lend it to a friend? No, we all know this because we have, collectively, culturally, hundreds of years of experience with a very stable system of personal property law. We don't attach strings to personal property, right? You wouldn't go out and buy a pair of shoes and ask the sales clerk to review the agreement that comes with your pair of shoes to make sure you're allowed to wear your Nike shoes with your Adidas shorts, or if you're allowed to, go jogging on Tuesday. You can do whatever you want with your new pair of shoes, right? When the exhaustion principle is working well, the same thing is true for copies of books and music and movies that we buy. Exhaustion does both of those things, right? It creates these incentives for consumers, it reduces information costs, but it also preserves the incentives for creators. Copyright law is understandably very focused on making sure that authors have the right set of incentives to invest in creating new works. Exhaustion only happens when there is a transfer authorized by the copyright holder at a price that they set. You sold the book. You determined what price to sell the book with the understanding that once you sell it, consumers are allowed to do these things with it. So that's a really good way of making sure that creators get some kind of return on their investment. So it's an important principle, but it's a principle that is being undermined in a lot of important ways over the past decade or so. The first key development here that leads to this problem is kind of the changing role of the copy in the world that we live in. For most of copyright's history, consumers interacted with copyrighted works in the form of tangible copies. They read hardcover books, they rented video cassettes, they listened to vinyl records, and that is changing, and changing really quickly. That was true really since Gutenberg introduced the printing press in 1450. We've been interacting with works in a tangible format. There were counterexamples to that. There were live performances, there was broadcast, there was, theatrical exhibition, and those were important in some areas. But for most copyright holders, they made their money selling copies. I'm not great at math here, right? But what is that? 550 years or so, we followed that basic model. And in the last 12 years, we've shifted away from that model, and we've shifted away from it actually 3 different times in this really short span of time. So first we move from hard copies to downloads. This starts in earnest in about 2003 when Apple introduces the iTunes Store. Physical sales plummet, digital sales of music skyrocket, and it's not long before most people are buying their music digitally rather than through tangible copies. Ebooks explode in popularity from being non-existent to accounting for somewhere between 1/4 and 1/3 of the book market now. Similar rapid growth for movies. But then really quickly we shift away from downloading physical copies to cloud-based distribution. You don't want to lug around a hard drive that has everything you've ever purchased on it. We want small, light, mobile devices. We have ubiquitous high-speed internet connections. So keep all that stuff on someone else's server and just access it when you need it, right? That's sort of the cloud-based distribution model. And with both of these models, there's still copies, but there are hard questions to answer about exactly where those copies are, how long they last, and whether they count for copyright purposes as a result of their sort of short lifespan, and who owns them, right? Those are not easy questions to answer, right? You buy a digital movie, and it's stored not on your hard drive, but on Amazon servers somewhere, and you get to watch it. You get to press the play button, and it streams to your device. Do you own that copy? I don't know. Amazon certainly says you don't. I mean, you can imagine a story to tell with sort of analogs to the tangible world, right? I own Grandpa's stamp collection, even though it's in a safe deposit box at the bank on Main Street. I don't have to have something in my physical possession to own it. Do we think about cloud copies in the same way, right? Do you own those things, or are you just sort of allowed to access them for a fee? Copies are everywhere in the digital environment. Copies used to be really valuable things. They were durable, they were rare, they were hard to make. Now copies just sort of blink in and out of existence all the time, and nobody notices, right? The movie I was watching on my iPad earlier, it was there for a while. It's gone now, but if I want it, I can get it back. We don't attach the same value to particular copies as we did in the past. We're starting to see courts really struggle with sort of their fundamental, first step in the copyright analysis, which is identifying whether a copy exists. They have trouble with this now. You have services, there's this company, Redigi, that created a digital marketplace for used MP3s. You bought an album on iTunes, you decided, I'm not really into this anymore. I bought it for 99 cents a track. Maybe I can sell those tracks for 29 cents to someone else, right? In the same way the used record store works. So they created this system to kind of facilitate those sorts of transactions, but keep the integrity of a resale model, right? To make sure that actually only one copy exists at a given time, and that when person A transfers their rights to person B, they don't get to keep a copy for themselves. And you can see the court there really struggling with this almost metaphysical question about, wait a minute, is that the same copy that you had to begin with, or did you create a new copy and destroy your old one? And should copyright law care about drawing that sort of distinction? Copyright law doesn't have particularly useful answers to these questions right now. So those are the first two shifts in our distribution model. That leads us, as all things apparently do in this decade, to Taylor Swift. So now we're functioning largely in a model where streaming of content is the dominant way that consumers are accessing copyrighted works, or at least we're trending in that direction. So Netflix and Spotify are poised to overtake not only hard copies, but also downloads, also cloud-based distribution within the next few years. CD sales this year continued to plummet. Digital downloads were down 10%. Spotify increased by 54% this year, right? Huge, huge increases. Similar story is playing out in the world of movies. By 2016, digital distribution is going to overtake physical distribution for movies and television. Most of that revenue, by a sort of 2-to-1 margin, is coming from streaming. And this is great for consumers for a lot of reasons. The price point is really low. The selection is great. It's really portable. It's really convenient. I understand why consumers are making this choice. It's a choice I make pretty often myself. And there are lots of upsides for copyright holders and providers of these services. They get mountains of data about what you watch, when you watch it, how often you watch it, and how long you watch it or listen. That's really valuable data to companies that are in the business of producing content and hoping that you like it. This is why Netflix doesn't do pilots. Netflix ordered an entire season of House of Cards because they knew before they made it that you would like it, because they've been watching everything that you watch and learning lots and lots of information about all of us. The price point is low enough here to potentially reduce infringement. Those people who are kind of on the fence about should I pay or should I not, it seems more reasonable to a college student to pay $8 a month for Netflix than it does to pay $15 for each movie that they want to buy. It also combats resale, right? No one owns anything under this model, so there's nothing to resell, and that in itself, I think, is useful. What's this look like from the creator's standpoint, though? There are downsides. There's a reason that Taylor Swift and lots of other artists are either pulling their content from Spotify altogether or are complaining bitterly about the 5-cent royalty checks that they've been receiving in the mail. What do we do about that? One answer might just be, yes, Spotify is greedy. They're not sharing enough of their revenue. They've actually paid out $2 billion to copyright holders over the last few years. Maybe the answer is Spotify doesn't charge its consumers enough. Maybe they have too many people on their free tier of service and they're not charging enough for advertising. They need to get people over to the premium service. But again, $2 billion is a fair amount of money, 70% of their revenue, in fact. Most of that money, it turns out, ends up not with the artists who are getting the 4-cent royalty checks, but with their record labels. Ask anyone in the music industry if they are surprised by that fact, and they will tell you no. So Taylor Swift knows this. She's smart. She's sophisticated. She's a business person poised to dominate this planet that we all live on. So why is she making this decision? Why is she pulling out of this service knowing that it's not Spotify's fault that she's not making as much money as she might otherwise like to? I think there's a better explanation for what she's doing. She's not interested in just selling records. She's interested in creating a dedicated fan base. She's interested in people who buy records, who buy $100 concert tickets, who buy T-shirts, she's in the process of trademarking lots of phrases associated with her, like, snippets of her lyrics, to sell lots of products, right? There's going to be all sorts of Taylor Swift branded merchandise. This is not about record sales. This is about something very different. She wants more of a commitment from all of us, right? She doesn't want... great, you listen to Taylor Swift on Spotify, maybe you like the songs, maybe you sing along. That's not the same thing as, pressing that button that says buy now and spending your $10, or actually going to the record store and buying the CD. That puts you in a different frame of mind where you self-identify as a Taylor Swift fan, not as a person who sees her music as kind of, pleasant but undifferentiated from the rest of popular culture. So ownership, it turns out, is not only good for consumers, it might actually be good for creators as well. So second problem, right? Problem one is we're shifting away from a marketplace that relies on the copy, and the copy is the thing that consumers have traditionally owned. The other problem here, and this achieves that same result in some ways a much more direct way, is that we have all of these license agreements that attempt to redefine transactions that any sane person would call a sale and call them something else, right? We call them licenses. And exhaustion only applies if you're an owner. It doesn't work if you are a licensee. So if you can characterize the transaction as not a transfer of ownership, but a mere license, then you have no rights as a consumer to that thing. This is a problem that really has its roots in the software industry. Software licensing is where this sort of approach and this mentality originates. But there's no reason to expect it to stay confined to software. The line between software and other kinds of media has always, frankly, been fairly blurry, and it's getting more blurry as time goes on. And you see other industries identifying this strategy and making explicit efforts to import it into the world of other kinds of copyrighted works. It used to be really easy to figure out whether you own something. So this is the copyright page from a book called The Castaway that was published in 1907 by the Bobbs Merrill Company. This was the subject of the first Supreme Court case to deal with the first sale doctrine. That's a case called Bobbs Merrill versus Strauss. And if you can't read this little legend here, it says, the price of this book at retail is $1 net. No dealer is licensed to sell it at a less price, and sale at a less price will be treated as an infringement of the copyright. Our book costs $1, and if you sell our book for less, you're a copyright infringer. The Supreme Court, so this is sort of like a proto-license agreement, right? It's an attempt to kind of restrict what you can do with the thing that it looks like you're buying. And the Supreme Court doesn't even bother to entertain the idea that this interferes with personal property rights. Did you buy this thing for a one-time price, or was there an ongoing obligation to pay? If it's a one-time price and you get perpetual possession, it's a sale of it is a sale and a transfer of ownership. Today we have things that look like this. This is the iTunes license. The current iTunes license, by the way, is longer than Hamlet. I don't actually know how long Hamlet is, but I don't know. It's probably pretty long. Java, right? Someone did the math on this. So Java gets downloaded millions of times a day on people's computers. And if you take the number of Java downloads per day and you multiply it by the amount of time it would take the average person to read the Java license, assuming we all do this, I'm not exaggerating. Java requires 7,000 years of human attention every single day for people to read the software license, right? Something's wrong in that scenario, right? So these licenses say lots of things, and they have all sorts of questionable or objectionable terms. The thing I'm interested in is the fact that they say this is not a sale, it is a license. The iTunes license says that. It also bizarrely says all sales are final. I don't know what sales they're talking about because they've disclaimed the fact that any sales are actually going on. The iTunes license also says things like you should not use the iTunes software, you are prohibited from using the iTunes software to operate a nuclear facility. That's just nonsensical, right? You cannot, I don't know, I don't care how smart you are, you cannot use this software to operate a nuclear facility, right? So these licenses have all sorts of terms that dissuade consumers from actually investing the time to understand what they say. The law here is really a mess. Courts have adopted all sorts of different inconsistent tests for whether or not a license agreement successfully transforms a transaction from a sale to something less than a sale. The Ninth Circuit decided 2 cases on the same day, decided by the same 3-judge panel, and they adopted totally inconsistent tests in those 2 cases, right? That gives you some sense of where the law is here. But the takeaway is that at least for software, a transaction defined by a one-time payment, right? I go into the store, I pick up a copy of AutoCAD. I spend $7,000 on a copy of AutoCAD. One-time payment, perpetual possession, I get to keep that thing as long as I want. And courts say that plastic disc that you walked out of the store with, you don't actually own it. You are licensed to use that tangible object, right? So today these rules are kind of confined to software, but as I said, I don't think they're going to stay confined to software. So if consumers want to really own things, why do they keep entering into these transactions? One reason is the information costs are just too high for them to bother engaging with this material. The other part of that story, though, is that I think these transactions are being presented in a way that kind of preys upon consumer expectations about ownership. So you go to Amazon to buy your copy of 1984, and Amazon invites you to buy now with one click. And that language, buy now with one click, is the exact same language that you would see if you were buying a hardcover version of 1984. It's the same language you would see if you're buying like a bag of kitty litter on Amazon, right? The difference is your hard copy of 1984, presumably your bag of kitty litter, does not come with some sort of restrictive license agreement attached to it. So I think this word buy, like the word own or the word purchase, communicates something to all of us. We have expectations about what it means to buy something or own something or purchase something, right? Words have meaning. And we associate certain rights with ownership, with purchasing, with buying. Alienability is one of them. We expect that if we buy something, we can get rid of it, we can sell it, we can give it away. We expect that we can repair the devices that we buy. We expect we get to keep the things that we buy as long as we want. That's a pretty fundamental assumption of ownership, I think. But none of those things are true of your digital purchase of 1984. You can't resell it. You can't give it away. You can't lend it. And one morning you might wake up and it's just not going to be there anymore. So I'm in the process of putting together an experimental study of about 1,000 consumers where we are going to test what assumptions consumers bring to the table when it comes to words like buy or purchase or own. And we're going to find out if, in fact, as I suspect, Amazon's actually engaged in false advertising here. Right? They're promising one thing, buy, which we assume comes with these sorts of rights. And then in the license agreement, they're actually taking away those rights and not making good on this promise. So, in a month or so, check back and maybe I'll have an answer to this question. The final thing that I want to talk about here in terms of where this problem is coming from is the notion of digital rights management. So digital rights management technologies, or DRM, these are all of those sort of software locks that you run into as a digital consumer. When your device tells you, actually, wait a minute, you're not allowed to use the thing in the way you want. So here's my computer telling me that even though I bought a copy of Harry Potter and the Deathly Hallows Part 1, from Apple, my computer isn't authorized to play it, right? There's some little bit of code here that limits the number of computers that a person can be logged into or authorized on to play these files, right? So it might tell you that you can't convert files to your format of choice. It might limit the number of devices that you can play your stuff back on. It might limit the number of times you can copy a file. Maybe most importantly, it restricts what kinds of devices you can use. If you bought an ebook, an iBook from Apple, good luck reading it on a Kindle, right? It just doesn't work. You can't do it without breaking the DRM and, in fact, violating Section 1201 of the Copyright Act. And DRM is no longer just about video games and movies, if it ever was. This is a screen that you might see when trying to brew unauthorized coffee on your new Keurig coffee maker. So if you can't read that, it says, this pack wasn't designed for this brewer. Please try one of the hundreds of packs with the Keurig logo. So if you're buying discount coffee, right, there's a bit of software on this device that knows what kind of coffee you're using, and if you're buying the wrong one, sorry, go back to the store. Do you own a coffee maker that will not brew the coffee that you want, right? I'm inclined to say no. The best and maybe most offensive part of this is the URL that you are instructed to go to when you run into this problem. It says, questions, visit Keurig.com/oops. Oops. This is not an oops, right? This was not a mistake. This was an intentional design decision, right? So if you want to own things, if it matters to you that you own things, these trends might be a problem. Now, not everybody cares. I talk to lots of people, and I get this response traditionally from people on the younger end of the age distribution who say, I don't care about owning things. I'm happy with Spotify. I just want, I think these things are disposable and temporary and fleeting. And I'm okay with that, right? And I think that's fine. I think that's a choice that consumers should be able to make. I also think the other choice, the choice of permanent, stable, predictable property rights, is also a choice that consumers should be able to make. And I want to make sure that we're living in a world where both of those options are on the table and consumers can actually express their preferences. So what do we do about this? If you think this is a problem, how do we address it? There are a few options here. Some I think are better than others, right? So maybe there's a marketplace solution for this, right? Maybe competition and consumer demand will be enough to preserve consumer property interests. And people say this, right? People say, well, yeah, sure, every once in a while a company like Keurig is going to come out with a new coffee maker that doesn't listen to you, that doesn't do as it is told, and they'll pay a price in the marketplace for that decision. There will be a backlash. This happened quite effectively, actually, a couple of years ago. So when the new gaming consoles were being introduced, the Xbox One and the PlayStation 4, Microsoft announced that it was going to implement some technology that would restrict the use of used games. So used games are a huge part of the gaming industry and sort of the bane of the existence of game publishers. And so Microsoft, working with them, said, look, we're going to tie the disk to an individual user account. And that way, if you sell it to your friend or you sell it to GameStop or one of these used stores, it's not going to be any good to the second purchaser. So they can clamp down on this resale market. And consumers threw a fit. Through such a fit so effectively that within a couple of weeks, Microsoft said, yes, sorry about that. That was a really bad idea. We're not going to do it. Right? That's one example of the market working. Can we expect the market to work that well all the time? I think not. For some reasons that I've already talked about, right? There's, I think, a real confusion amongst consumers about what they're actually buying. For consumers to react against the idea of not having personal property rights, they have to know that they don't have personal property rights. And I think lots of consumers are uncertain about the nature of these transactions. The other problem is that these information costs are so high that even if some enterprising ebook retailer decided, you know what, our license agreement is going to be a little bit different. We're going to actually make this a sale, and people will have the opportunity to engage in all of the sorts of practices that we associate with ownership. That relies on consumers being able to distinguish in the marketplace between those people who are providing sales and those people who are providing licenses. That means that consumers have to dig into both of those agreements to tell the difference between them. I don't think they're going to do that unless we come up with a much more effective way of communicating these distinctions, right? So really high information costs, consumers have very little incentive to read. And if consumers aren't reading and they can't tell the difference, and there's very little incentive to actually compete on these terms, this is sort of the classic market for lemons problem, right? We might see and do already see to a small extent licensed secondary markets for lending or for resale. So some Kindle books come with a lending option. You're allowed to lend the book one time and only one time, only if the publisher has opted in to lending, and most of them have not. And it only allows you to lend the book to another Kindle user. You can't, lend your Kindle book to someone who's reading on a Nook, for example. All right, so if the market's not going to work, maybe law can help. And there are a couple of ways that law could intervene here. One way is through courts. Copyright exhaustion was created by courts. It's a common law doctrine. that dates back explicitly to the late 1800s and is really rooted in common law principles that are a couple of hundred years older than that. So I actually think courts are empowered today to start interpreting these exhaustion principles a bit more broadly than they have, in a way that extends beyond the right of distribution to include the copies that are necessary to move digital files around, for example. But I don't think courts are necessarily going to be comfortable with that kind of expansion without some kind of statutory guidance or statutory cover. I have an article that actually just got posted to the internet yesterday that outlines a legislative solution to this problem. We are in the long process of reforming the Copyright Act, and I think one thing that needs to be addressed is how this first sale doctrine plays out in the digital context. Finally, we might rely on technology as either an alternative or a supplement to these legal changes, right? So, we might want some system that ensures that a single digital purchase isn't spawning, copies in the hands of dozens or hundreds or thousands of people. That's not what exhaustion is meant to do. You could use digital rights management technology to achieve some of this goal. I think another potentially less intrusive way is through some sort of public recordation of rights in digital assets. So if you know anything about the blockchain technology that's used by Bitcoin, that gives you some indication of my suggestion here. So the basic idea here is to have a publicly maintained database of digital assets and their owners so that we can track who has rights in these digital assets. And it serves a lot of the same purposes as sort of recordation in real estate transactions. It also helps because exhaustion is an affirmative defense, and so it would provide the kind of evidentiary record necessary to prove an entitlement to that defense, and I think would serve as kind of a check on abuse of this principle. So that's a really quick outline of what we might do to address this issue. Why don't I stop here and take your questions? Yes?
What about inheritance rights to these digital assets?
Yeah, so it's a great question. What do we do when, as inevitably we all will, people die, and what happens to these digital assets? Right now, that question is determined largely on the basis of these license agreements. I think Facebook just recently has allowed its users to essentially identify a digital heir who gets control of their account in the event of their death, right? Most license agreements do not address this question. And we might not feel comfortable with the idea that Amazon gets to determine the answer to that question. So I think one important consequence of treating these digital purchases like any other kind of personal property is that they do kind of fall within the general rules of inheritability. Delaware, I think, is the first state to talk about this question, to address it, and has some rules in place now for, to answer this question about inheritability. But they exclude all kinds of intellectual property from those rules, right? They didn't want to wade into this particular question. And so we don't have a lot of guidance here, but I think it's hugely important and something that is, we're only 10 years into this experiment in the digital marketplace, really. In the next 20, 30 years, this is a question that is, I think, absolutely going to be on the minds of more people.
Do you think a license now by
that's the test, right? So we're gonna divide consumers up into two groups, right? So the question is whether a license now button is going to make a difference. It might not make a difference so let me back up. So the basic structure of this experiment is that we will divide consumers first into different media categories, because I want to see if people's expectations about books are different from their expectations about movies, or different from their expectations about music. And then within those categories, half of them will be shown an Amazon-like product page using the buy now language, and the other half will be shown some alternative that right now is licensed now. It might change. It might be something else. That might not be the best way of capturing it. And we're going to see if consumers have the same set of expectations about what rights come with that transaction. My instinct is that people will have a different set of expectations when they see the license now language. But that's a different question from whether it will matter, right? Is it material to consumers' buying decisions? Are they still willing to enter into the transaction knowing that they aren't getting those rights? I don't know the answer to that question. I think that's a harder one to predict. And really the question is, are they willing to pay the same price, right? So materiality isn't just about sort of a binary, do you buy or not buy? It's what price are you willing to pay? And I would imagine that consumers are willing to pay more for things that come with meaningful property rights than things that have these kind of contingent contractual rights. But I don't know. I mean, that's the reason to do the experiment. So I have a hunch about which way it's going to turn out, but I'm really interested to find out. Yes.
Professor Perzanowski, I'm sorry if I mispronounced it. Fascinating presentation today. I'm also very interested in your thoughts about this recent famous case of Marvin Gaye's rights and what's really going on here, because there are attorneys pro and contra. What's really happening here in terms of jury instructions and in terms of what exactly you are looking for in such a case? Thank you. Yeah,
so that's a great question. So this is a case that got decided by a jury just last week, I guess, right? So this is the case where the estate of Marvin Gaye was suing Pharrell Williams and Robin Thicke for their recent mega hit song, Blurred Lines, right? That's the name of the song. And so what's going on here, right? So the Marvin Gaye estate owned the rights to the composition of his song. They didn't own the sound recording, right? So there are two different rights at issue in music copyright. There's the composition, which you can think of as like the sheet music, and then there's the copyright in the actual recording and what the musicians do in the studio. The label owned the sound recording copyright. The Gaye estate owned the composition. And a lot of the criticism, so the jury found in favor of the Gaye estate and awarded them something like $7.5 million in damages. And there's been a lot of criticism of the outcome in this case because, and I have to say I haven't reviewed the evidence in any great detail here, but the theory is, or the popular understanding is that the similarities in the songs were at the level of the sound recording, right? That the things that made the song sound similar, the use of cowbell, for example, or certain kinds of kind of vocal flourishes that Robin Thicke used that were very reminiscent of the kinds of things that Marvin Gaye would do, were not reflected in the composition. They happened in the studio, but that's not the copyright that the Gaye estate owned and that they were suing under. And so the question is, how do we reconcile that fact with the verdict that comes back from a jury? Part of the answer is it's a jury, right? Who knows what they do? Who knows what they're thinking? Who knows what influences those decisions? I think it's really hard to predict. There's also a fair amount of uncertainty in copyright law. regarding the appropriate tests to apply. And in the Ninth Circuit in particular, there's this sort of convoluted mess of the intrinsic and extrinsic tests, which, we've only got 5 minutes, so luckily I don't have to try to explain what's going on with that test for infringement. And so, you take uncertain and unclear law and layer that on top of the just general unpredictability of a jury decision that gets influenced by lots of factors, some of which are legally relevant and some of which are not. And this is the sort of outcome that we see. We have a sort of cultural, historical, constitutional commitment to this idea of the jury system, and the jury system, of course, plays a really important role in our judicial system. I'm not always convinced that it is appropriate in certain kinds of intellectual property disputes. I don't know that it's the best, most predictable or reliable way of getting results that make sense. But that said, I haven't sifted through the evidence, so I can't say for sure that the jury got this one wrong. Juries get things wrong a lot, in our system. So in some ways, it doesn't surprise me that much.
Yeah. I was just going to point out that there was a number of admissions by the people, Pharrell Williams as well as Robin Thicke, as to their intentions of making a song that sounded like, and they just, I think, talked too much for the jury to be able to, agree, because you never heard admissions like that in a case before almost.
Yeah, so that raises another really interesting, challenging question for copyright law, right? So copyright is supposed to be focused on the expression of the author, not the ideas underlying the work. And is there anything wrong with being inspired by Marvin Gaye? Who is making music, that we could, broadly classify as pop music or R&B music in particular, who is not inspired by Marvin Gaye, right? Were they inspired too much? I don't know. Maybe the lesson here, for artists in the future is to be less respectful or to give less credit, right? That's sort of a perverse incentive, right?
They were the soundtracks to try to stay away from whatever the filmmaker had wanted to put a popular thing, couldn't afford it, and so the composers has got these places that fit stuff in,
right?
And they're trying not to get too close. So sometimes they don't even want to hear what the person has put in.
Yeah. I'm sure the estate of Marvin Gaye is happier with $7.5 million than they are with someone, paying homage and giving respect to him. But in the future, they might not get either, right? Because, defendants are going to be more sophisticated and say, Marvin Gaye, never heard of him, right? And, I don't know if that's the outcome that we should hope for.
Question. I think your third benefit you're talking about in first sales, consumer privacy. As we move to a cloud, as we move to a situation where your IP gets identified, when I log on to download something, I have to give information. With cookies coming by and tracking all sorts of information where I may be visiting, are we moving to the point where there will be no privacy on anything that we do digitally?
Yes. That's the short answer, right? This is a real problem. It's something that I talk about in the book in a little bit more detail. But so a recent example of this, so Adobe has a software program that it's sort of its platform for ebooks. And it turns out Adobe software was tracking not only every book that you purchase and load onto your device, not only every page that you read, not only when you read that page and how long you lingered on it, but it was reporting all of that data back to Adobe, unencrypted, over the internet, right? which means it's essentially there for the taking. Now, maybe what I'm reading is not particularly interesting. Maybe what I'm reading is not particularly controversial. Maybe no one has any interest in it. But there are plenty of people in our society who are reading things that they would prefer to keep quiet for one reason or another.
Let me follow up if you don't mind.
No, please.
I do a lot of criminal law. Let's say that one of my clients happens to go with Grand Theft Auto, and there's violence in that. Will there come a time where I should be expecting the prosecutor to go after records to show that he particularly enjoyed bashing someone over the head? Abby Hoffman wrote a book called Steal This Book. This was back in the 60s, but they still suggest making bombs. One of the benefits you talked about was the privacy, being able to give it to someone without having someone such as the government track you. Do you see any way to combat in the coming days?
Yeah, so this is a real problem, right? We for a long time, and we don't have quite as strong a norm anymore, but in the library community, library records were sort of sacrosanct in terms of privacy. The Patriot Act changes that a little bit. If you think back to the confirmation hearings of Robert Bork, where his video rental history was released in the Washington Post. We got a fix to that really quickly, right? Congress looked around and said, "Wait, they can get a list of the videos I rented." Legislation passed, right? That protects the privacy of video rental records. So, I think there is, an opportunity for some kind of legislative fix. But the better solution is one where people are free to exchange ideas and exchange information without being tracked in the first place. And I think that historically, at least, Exhaustion has done that. Although the technological solutions that I talked about, DRM and a sort of public ledger, are in some ways inconsistent with those privacy interests as well. So, there can be fixes, but there is something fundamentally more trackable about digital information. Thank you all very much. I'm happy to stick around and talk more if anybody has other points to raise. Thanks.